Tennessee Valley Authority versus Hill, 1978, Case Law Review, ESA and NEPA Statute Analysis. In this landmark case, the Supreme Court upheld the strict protections for the Endangered Species Act, ESA, ruling against the construction of Tellico Dam in Tennessee that would have threatened the habitat of the endangered snail darter fish, Persina tenasi. The snail darter fish did not have a designated critical habitat at the time of the case, but the district judge found that the free-flowing river is the likely habitat of one or more of 7 rare or endangered fish species. The population of the 3-inch endangered snail darter fish was found to range from 10,000 to 15,000 individuals within the area. The district court made the following findings that the snail darter requires for its survival: a clear, gravel substrate, large to medium, flowing river with high oxygen levels. Since it tends to exist in the bottom of the river, the flowing water provides the necessary oxygen at depths. Installation of the dam stagnates the water, instills a more silted bottom, and reduces oxygen levels in the waters, exacerbating difficulty in the endangered species' capacity to survive. Reservoirs, unlike flowing rivers, tend to have a low oxygen content at greater depths. The reproduction process of the species would become heavily impacted as the eggs would become smothered by the increase in silt and reduction in biological factors the larvae would rely on. It was deemed the reservoir environment would be unsuitable for spawning reproductive processes.
Smash the like button and help support my channel so I can create more videos for you.
To make matters worse, the species' main source of food, snails, was deemed to not be able to survive in such an environment. Without their primary food source, capacity to not be smothered by silt, capacity to have adequate oxygen levels or reproduce, it is clear the construction project would surely be a prohibited take upon the listed species. The Secretary of the Interior, who originally made the ESA endangered species designation to list the species and protect it from unlawful take, went on to explain the significance of the dam's impact on the snail darter. The Secretary stated within the case that the snail darter relies on clean, flowing water habitats for spawning and feeding and resides in the swifter portions of shoals over clean gravel substrate in cool, low turbidity water. Food of the snail darter is almost exclusively snails, which require a clean gravel substrate for their survival. The impoundment of water behind the proposed Tellico Dam would result in total destruction of the snail darter's habitat. When fully operational, the dam would impact 16,500 acres of valuable and productive farmland, as well as convert shallow, fast-flowing waters into a deep 30-mile reservoir. Secretary went on to explain the significance of the dam to the habitat of the snail darter. The snail darter occurs only in the swifter portions of shoals over clean gravel substrate in cool, low turbidity water. Food of the snail darter is almost exclusively snails, which require a clean gravel substrate for their survival. The proposed impoundment of water behind the proposed Tellico Dam would result in total destruction of the snail darter's habitat. The snail darter fish relies on clean, flowing water habitats, particularly in rivers and streams, for spawning and feeding. Importantly, the Endangered Species Act, ESA, must be interpreted liberally to protect endangered species as well as their habitats. Construction of the dam threatened the habitat and survivability of the endangered snail darter fish, which would yield an ESA prohibited take upon the ESA-listed species. Designation. The Endangered Species Act of 1973 authorizes the Secretary of the Interior within ESA Section 4 to declare a species of life endangered. ESA Section 7 specifies that all federal departments and agencies shall, with the assistance of the Secretary, utilize their authorities in furtherance of the purposes of the Act by carrying out programs for the conservation of endangered species, and by taking such action necessary to ensure that actions authorized, funded, or carried out by them do not jeopardize the continued existence of such endangered species and threatened species or result in the destruction or modification of habitat of such species, which is determined by the Secretary to be critical to the species' survivability. University of Tennessee ichthyologist Dr. David A. Etnier found a previously unknown species of snail darter porcina, Imistoma tenaci, which was successfully petitioned to become protected as endangered under ESA. Shortly after the Act's passage, the Secretary was petitioned to list the snail darter as an endangered species under the Act. The Secretary designated the species endangered and declared areas to be the snail darter's critical habitat. Within 90 days of receiving a petition, the Secretary must determine whether the petition presents substantial scientific or commercial information justifying the listing or delisting of a species. The Secretary of the Interior has exclusive authority to determine a species is endangered or threatened, and to ascertain the factors which have led to such a precarious existence. The Secretary of Interior promulgated regulations which declared the snail darter an endangered species whose critical habitat would be destroyed by creation of the Tellico Reservoir. No judicial review of the Secretary's determinations has ever been sought, and hence the validity of his actions are not open to review in this case. Critical habitat. The Secretary designates critical habitat for the species if it is considered necessary for its survival. All federal agencies must take such action as is necessary to ensure that actions authorized, funded, or carried out by them do not result in the destruction or modification of this critical habitat area. The Tellico Dam was designated to be a critical habitat of the endangered snail darter under 50 CFR Section 17.81. Therefore, action must be taken to ensure that actions authorized, funded, or carried out by TVA do not result in the destruction or modification of this critical habitat area. For this case, it was highly controversial the fact that this case included a virtually completed dam for which Congress has expended more than $100 million to get over 80% constructed before an injunction halted work from continuing. Congress continued to appropriate large sums of public money for the project, even after congressional appropriations committees were apprised of impacts to the survival of the snail darter. The Secretary determined that the snail darter apparently lives only in that portion of the Little Tennessee River that would be completely inundated by the impoundment of the reservoir created as a consequence of the completion of the Tellico Dam. He declared that area as the snail darter's critical habitat, declared that, pursuant to Section 7, all federal agencies must take such action as is necessary to ensure that actions authorized, funded, or carried out by them do not result in the destruction or modification of this critical habitat area. Respondents brought this suit to enjoin completion of the dam and impoundment of the reservoir, claiming that those actions would violate the Act by causing the snail darter's extinction. Irreversible impacts. It is important to consider the irreversible impacts that a take yields because once a species is extinct, there is no way of protecting or bringing this species back. The ecological benefits the species provides society is irreversibly lost. Biodiversity is forever reduced. In this case, the construction of one dam, which is optional and not required for the survival of humankind, is placed against the irreversible value of this species that risks extinction, as well as multiple other rare species impacted by the destructive habitat losses caused by the dam construction project. The case included controversial determinations by the district court that were overseeded and eventually reversed by the Court of Appeals. The district court wrongfully favored the continued construction of the dam due to irretrievable previously committed large sums of resources and money into the project over the past decade. Instead, once ESA was placed into law and the snail darter became a listed endangered species, the district court was judiciously required to fulfill the intent of both the Endangered Species Act, ESA, and National Environmental Policy Act, NEPA. The intent of both statutes must be fulfilled within their decision. Instead, the district court decided to lift the injunction to allow continued dam construction and irreversible impacts to ESA-listed species. We find the irretrievable commitment of resources by Congress to a project over a span of almost a decade is a moot point that does not justify unlawful actions. They do not justify a prohibited take of any species. Later, we will go into the Court of Appeals' determination on this matter. Intent. Throughout this case, the intent of ESA was analyzed and heavily considered for deciding the case. We agree with the petitioners that the intent of ESA is to prohibit a federal agency from taking action which does jeopardize the status of endangered species. Supra at 437 U.S. 179. As practicable, ESA requires federal agencies to protect species and, insofar as is practicable and consistent with their primary purposes, Section 1b. 80 Stat 926, preserve the habitats of such threatened species on lands under their jurisdiction. The term practicable emphasizes the need for practical and informed decision-making. We find that if actions are practicable and feasible to protect species or their habitat, actions should be taken to protect the species and critical habitat. Take. Here we will go into the depths of ESA by defining a take and harm based on the findings of this case. The intent of ESA is to ensure no unlawful take of a listed species. The definition of take under the statute is to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect such life forms. In this case, the construction of the Tellico Dam would have resulted in the destruction of the snail darter fish's habitat, constituting a take under the ESA. The ESA take occurred through the proposed habitat destruction due to the dam construction. We find that a prohibited take against the snail darter fish had already occurred because the construction was over 80% completed before injunctive relief was provided to halt further species degradation. The Court of Appeals decided upon permanent injunctive relief following the district court's determination to lift the injunction within its nearly fully constructed status due to its intent to place social economic values over the value of this species that risks extinction. Harm. The definition of harm under the statute is any act which annoys wildlife to such an extent as to significantly disrupt essential behavioral patterns, which include, but are not limited to, breeding, feeding, or sheltering, significant environmental modification or degradation.
Smash the like button and help support my channel so I can create more videos for you.
The Secretary of the Interior has defined the term harm to mean an act or omission which actually injures or kills wildlife, including acts which annoy it to such an extent as to significantly disrupt essential behavioral patterns, which include, but are not limited to, breeding, feeding, or sheltering, significant environmental modification or degradation which has such effects is included within the meaning of harm. 50 CFR Section 17.3, 1976. For the Tellico Dam in Tennessee project, the court found essential behavioral patterns of the species, i.e. breeding, feeding, or sheltering, are significantly disrupted by the operation of the project. The construction threatened the habitat of the endangered snail darter fish. Prohibited actions. Under statute requirements, federal agencies are to ensure that actions authorized, funded, or carried out by them do not jeopardize the continued existence of an endangered species or result in the destruction or modification of habitat of such species. 16 U.S.C. Section 1536, 1976 edition. As case findings clarify, this language admits of no exception. NEPA consideration of alternatives. TVA was required to consider alternatives to damming the river in accordance with requirements of the National Environmental Policy Act of 1969, NEPA, 83 Stat 852, 42 U.S.C. Section 4321 etc. TVA was in violation of NEPA if it did not consider alternative actions to a take of the endangered snail darter fish. TVA was found to be in violation of NEPA until it filed an environmental impact statement for the project. TVA consistently took the position that the only available alternative was to attempt to relocate the snail darter population to another suitable location. TVA conducted a search of alternative sites which might sustain the fish, culminating in the experimental transplantation of a number of snail darters to the nearby Hiwassee River, in which it previously inhabited. Alternatives like the transplant of the species to a previously traversed Hiwassee River were considered, but biological and other factors for the river were deemed by the Secretary of the Interior to negate the possibility of successful transplant of the species. The Fish and Wildlife Service and Dr. Etnier stated it may take 5 to 15 years for scientists to determine whether the snail darter can successfully survive and reproduce in this new environment, and the snail darter does not presently reside in the Hiwassee River because a strong indication that biological and other factors in this river negate a successful transplant as being possible. Injunction. When an injunction was placed on the project initially, the district court found that the project was 80% complete and, based on available evidence, there were no alternatives to impoundment of the reservoir, short of scrapping the entire project, found that some $53 million of the $78 million already expended would be lost in non-recoverable obligations, or wasted if the dam was not completed. The court clarified that the Endangered Species Act of 1973 was passed some 7 years after construction on the dam commenced, and that Congress had continued appropriations for Teleco with full awareness of the snail darter problem. Assessing these various factors, the district court decided to lift the injunction in late 1973 as it deemed TVA's final environmental impact statement for Teleco was in compliance with the law. We find the problem here is that ESA prohibits a take. Therefore, even if TVA fulfilled TVA's administrative requirements of completing an EIS and considering alternative actions under NEPA, because alternative actions were deemed not viable, it could not justify the completion of the project because its action of finishing dam construction would cause an unlawful take upon an ESA-listed species, which means environmental effects of proposed actions outweigh societal and economic considerations that NEPA analyzes. Actions and prospective actions. ESA Section 7 defines actions as authorized, funded, or carried out actions or the act of deciding whether to authorize, to fund, or to carry out prospective actions, i.e. actions. Prospective actions require an agency to have reasonable decision-making alternatives still available for the actions that have not yet been carried out. At the time respondents brought this lawsuit, the Teleco project was 80% complete at a cost of more than $78 million. The district court decided here that the Teleco Dam project is completed or virtually completed, and the dam is essentially ready for operation at the point that it was deciding the case, thus justified lifting the injunction to allow the completion of construction of the dam. The district court recognized that Congress, when it enacted the Endangered Species Act, made the preservation of the habitat of the snail darter an important public concern. We find that the district court failed to protect the ESA-listed species, allowed an unlawful take of the species, and risked irreversible extinction of the species.
Definitely be sure to smash the like button.
Leading up to injunctive relief, Congress, though fully aware of the snail darter problem, had continued Teleco's appropriations and concluded that, at some point in time, a federal project becomes so near completion and so incapable of modification that a court of equity should not apply a statute enacted long after inception of the project to produce an unreasonable result. The committees consistently recommended appropriations to fund construction of the dam, sometimes stating their views that the act did not prohibit completion of the dam at its advanced stage, where Congress each time approved TVA's general budget for funding the dam's continued construction. Supreme Court ruling. The Supreme Court ruled in favor of protecting the snail darter, granting an injunction to halt the dam's construction under the ESA. A few months later, the district court's decision dissolved the NEPA injunction. District Court Decision Errors. The District Court denied injunctive relief because of significant public and social harms. The District Court decided that they could refuse to order a federal official to take specific action, like halt further construction of the dam, even though the action might be required by law, if such an order would yield public injury or embarrassment or otherwise be prejudicial to the public interest, who were thought to overall want the dam to be constructed. Here we find the court cannot refuse to make proper lawful orders. The decision to take no action against TVA is not justifiable under ESA. If a decision is required by law, the court is obligated to make that decision or finding in accordance with not just statutes but also regulations, policies, executive orders, etc. in place at that time. The decision must be lawful regardless of any subjective perception of any public injury or embarrassment. Here we also conclude their determination that a public injury or embarrassment existed was also unreasonable. The purpose of law is to ever evolve. It is not an embarrassment to be forced to halt a project due to a new ESA statute or new snail darter ESA listing. 7 years ago, the project began when ESA did not exist. The species was not ESA listed, or the presence of the species was unknown. Furthermore, no actual public injury existed. Instead, the notion was a deliberate exaggeration or hyperbole as the species was the one actually injured by the decision. We also find that the Mr. Chief Justice Berger erred in their finding that 1966 statute was not a sweeping prohibition on the taking of endangered species. Instead, the Act does specifically prohibit a take upon any listed species. We also find Mr. Chief Justice Berger erred in his interpretation of ESA Section 7, Section 2(b), where he justified actions when federal agencies use their authorities to insofar as is practicable and consistent with their primary purposes. We find that an agency should not justify, be excused, provided an exception, or allowed to perform a take upon a species or impact to critical habitat, regardless of their authority, primary purpose, or jurisdictional boundaries applicable to their actions. In simple terms, an agency shall take actions that are practicable and cannot take no action when it is practicable. The agency's purpose, mission, or jurisdiction should not be used as an excuse to take no action. The agency's purpose, mission, or jurisdiction should not be used as an excuse to cause a take or yield actions prohibited by ESA. Instead, the intent of the Endangered Species Act shall be fulfilled and the species protected. ESA instead states, federal departments and agencies shall, in consultation with and with the assistance of the Secretary, utilize their authorities, carry out programs for the protection of endangered species, and it further requires that those agencies take the necessary action that will not jeopardize the continuing existence of endangered species or result in the destruction of critical habitat of those species. The Secretary of the Interior shall review programs administered within the consultation process to ensure conservation of listed endangered and threatened species pursuant to Section 1533. The agency shall take actions under its authority to protect the species. Actions when practicable are required. No action is not justifiable. Instead, an agency must do their due diligence and do something to protect the species. The district court denied relief and dismissed the complaint regardless of finding that the impoundment of the reservoir would probably jeopardize the snail darter's continued existence. The court decided at some point in time, a federal project becomes so near completion and so incapable of modification that a court of equity should not apply a statute enacted long after inception of the project to produce an unreasonable result. We find that once it was determined a probable jeopardized existence of the species exists, injunctive relief must occur at this time. The extent that the project was completed was a moot point. Regardless of its status of completion, percentage of completion, or date the project commenced, the project can always be modified or halted at any time. This outcome is only reasonable. It is instead only equitable to apply all statutes lawfully regardless of their time of inception. Ever-evolving evolution of law. Not only is it lawful and equitable to apply all statutes to current situations that exist regardless of when they were enacted, but it is also justifiable to retroactively apply statutes to correct past injustices or address urgent issues. The study of law is ever-evolving. Retroactive application of law will depend on the legal intent and precedent set for each statute. The application of law into court decisions shall consider both legal case law precedent and the statute itself when decision-making. Court of Appeals decision. The Court of Appeals reversed the decision finding the district court erred in their decision. We agree with the Court of Appeals findings that both ESA and NEPA must be adhered to protect the species and its habitat. In alignment with the Court of Appeal findings, we agree that the district court's refusal to issue an injunction was an abuse of its discretion. The Court of Appeals decided, one cannot balance the worth of an endangered species against the value of an ongoing public works measures, emphasizing judicial power has limits, and the current project status for whether a dam is 50% or 90% completed is irrelevant in calculating the social and scientific costs attributable to the disappearance of a unique form of life. Courts are ill-equipped to calculate how many dollars must be invested before the value of a dam exceeds that of the endangered species. Our responsibility under Section 1540 G(1)(a) is merely to preserve listed species, which is why alternative actions must be considered and/or taken. It made no difference that Congress had repeatedly approved appropriations for Teleco, such legislative approval as an advisory opinion concerning the proper application of an existing statute. In that court's view, the only relevant legislation was the act itself, the meaning and spirit of which was clear on its face. The Court of Appeals ruled that the district court had erred by not issuing an injunction. While recognizing the irretrievable loss of millions of dollars of public funds which would accompany injunctive relief, the court nonetheless decided that the act explicitly commanded precisely that outcome. Welfare of an endangered species may weigh more heavily upon the public conscience, as expressed by the final will of Congress, than the write-off of those millions of dollars already expended. Teleco Dam will either eradicate the known population of snail darters or destroy their critical habitat. Therefore, a permanent injunction to halt the dam's construction was issued. We wish to add that the value of a species may in fact be priceless, so no dollar amount may be sufficient to offset its biological value to society. The Court of Appeals decided. The Court of Appeals reversed the decision and ordered the district court permanently to enjoin or prohibit the completion of the project until Congress, by appropriate legislation, exempts Teleco from compliance with the act or the snail darter has been deleted from the list of endangered species or its critical habitat materially redefined. It was found a prima facie violation of ESA Section 7 in that the Tennessee Valley Authority had failed to take necessary action to avoid jeopardizing the snail darter's critical habitat by its actions, where this term was not intended by Congress to encompass allowing terminal phases of ongoing projects. Congress affirms decision. It is held that the Endangered Species Act prohibits impoundment of the Little Tennessee River by the Teleco Dam. ESA Section 7 language is plain and provides no exception where the Act would not apply to a project like Teleco, even if it was well underway when Congress passed the Act. It is clear from the Act's legislative history that Congress intended to halt and reverse the trend towards species extinction, whatever the cost. Endangered species legislation reveals a conscious congressional design to give endangered species priority over the primary missions of federal agencies. Congress, moreover, foresaw that Section 7 would, on occasion, require agencies to alter ongoing projects in order to fulfill the Act's goals. None of the limited hardship exemptions provided in the Act would even remotely apply to the Teleco project. Nothing in the TVA appropriations measures passed by Congress stated that the Teleco project was to be completed regardless of the Act's requirements. As the petitioner has urged the decision should stand for otherwise, it would violate the cardinal rule that repeals by implication are not favored. 155 doctrine disfavoring repeals by implication applies with full vigor when the subsequent legislation is an appropriations measure. When voting on appropriations measures, legislators are entitled to assume that the funds will be devoted to purposes that are lawful and not for any purpose forbidden. Appropriations measures may not change existing substantive law. In simpler verbiage, Congress's action to provide funding to TVA does not authorize a change to ESA to authorize prohibited actions. Congress finds that the Court of Appeals did not err in ordering that completion of the Teleco Dam, which would have violated the Act, be enjoined. Congress states it is clear that endangered species are to be accorded the highest priorities. Since that legislative power has been exercised, it is up to the executive branch to administer the law and for the judiciary to enforce it when enforcement has been sought. pp. 437 U.S. 193 to 194. 549 F.2 D 1064. The Court of Appeals decision was affirmed. Interesting twist of events. TVA v. Hill set an important precedent by establishing that the ESA's protections should be interpreted strictly to protect endangered species and their habitats, even if it means halting large-scale development projects, regardless of how close they are to completion. As an interesting twist to events, the snail darter fish species was found to exist elsewhere throughout the United States. Had these snail darter fish been identified elsewhere throughout the timeline of the case, there is a chance TVA could have argued against the designation of listing the snail darter as an endangered species under ESA due to its larger population, range, and distribution than originally assessed by scientists. If the species was found to be actually abundant and its survival found to not be at risk, the completion of the dam may have been approved without any injunction or reversal by the Court of Appeals. Initially, the snail darter was thought to inhabit strictly the lower portion of the Little Tennessee River. Additional populations of snail darters were discovered in South Chickamauga Creek in Chattanooga, lower portion of Big Sioux Creek in Meigs County, lower Sequatchie River in Marion County, Little River in Blount County, lower portion of Paint Rock River in Madison County, Alabama.
Smash the like button and help support my channel so I can create more videos for you.
Thus, its range extends from major tributaries of the Tennessee River to northern Alabama and even Georgia. These findings eventually led to the species becoming reclassified from endangered to threatened in July of 1984, then later delisted altogether. The snail darter halted the construction of a federal dam project, but is no longer threatened with extinction due to identifying other populations of the species and, importantly, the success of conservation efforts that successfully relocated the snail darter to other rivers for it to thrive. In 1975, the species was successfully transplanted to the Hiwassee River, where the population has risen to about 2,500 individuals. Other transplant attempts were made to the Nolichucky River in 1975, but these were halted due to the discovery of another federally protected species, the sharp-head darter, Ethiostoma acuticeps. Once the species population rebounded to sufficient numbers for the species to be delisted, the dam was eventually built. Importance of ESA. ESA represents the importance of preserving biodiversity of species for future generations. Here, ESA proved a commitment to safeguarding seemingly insignificant species. Recovery was successful for the species. Extinction was avoided. Overall, a positive outcome and highly renowned precedent was made early on in the historical existence of ESA. This is truly a success story for the practice of environmental law. The intent of both ESA and NEPA were carried out. An EIS was completed, alternative actions implemented, eventual completion of the dam society wanted, and the species was saved with eventual delisting due to its increase in population. Here we learn, an injunction is not always permanent. The practice of environmental law is intended to foster conservation. Environmental law is intended to foster public health and safety. It is not intended to halt projects, instead only ensure projects consider environmental impacts, implement alternative actions, and/or implement the best available technologies whenever practicable. If a project is permanently halted, it is for a justifiable reason that probably benefits, protects, and/or prevents injury or death.
Smash the like button for the YouTube algorithm.
Please comment below. Is there anything you found confusing, or do you have any questions about this case? Do you like the outcome for this case? Comment below. Do you agree with the district court's findings that lifted the injunction to allow completion of the dam? Do you agree with the Court of Appeal's findings to reverse the district court's decision and order certain actions to occur in accordance with fulfilling ESA and NEPA requirements to not take, but also implement viable alternative actions? Do you think that there should be penalties for the take that already occurred from ESA's enactment to the date of the court decisions? Normally, homeowners must take certain actions for their property, or they gain jail time or fines. Should federal employees that allow unlawful actions be given jail time and fines too? Let me know your thoughts. I would love for us to really get deep into this case and analyze not just what happened, but also what did not happen. Should federal agencies be responsible for using funds for unlawful actions, and how should we penalize unlawful actions by officials? Please do like, share, subscribe, and comment below to help support this channel and help me succeed so I can post more videos for you. Feel free to check out Level Up with Alyssa Mahin YouTube channel to level up your life in a personalized way. See you there. Thank you all for joining me. Talk to you soon on the next one. Click on the on-screen images to subscribe and watch more videos.